Hey guys, this is John Watts. I'm a consumer protection lawyer, and welcome to our fourth video in this series on what does a 1099-C mean, the cancellation of debt. What does that mean for credit reporting? And what does that mean for debt collection? And are there situations where the debt collector saying that they will potentially report you with the 1099-C, does that violate the FDCPA? And so in this case, we're looking at a Seventh Circuit Court of Appeals case from 2019. Just by way of quick reminder, our first video, we covered the actual 1099-C, particularly this area down here, identifiable event. And we also looked at the instructions. And then in our second video, this had to do with credit reporting and does a 1099-C mean that I do not owe the debt anymore? And this is the Gugger case 2017. And then our third video was the Gugger case, but 2018 version of it. And then in this one, we're going to shift our focus away from does a 1099 mean that you do not owe the debt to can it violate the FDCPA when a debt collector threatens you? So pretty simple facts here. We've got Capital Management Services. They send out letters. Matter of fact, 4 letters to the consumer. And the consumer says that language violates the FDCPA, the Fair Debt Collection Practices Act. The debt collector disagreed, filed a motion to dismiss under Rule 12b-6, and the court granted that, which made the whole case go away. Then the consumer appealed, and the court says, we find that the consumer has plausibly alleged, which is the standard, plausibly alleged that the collection letter, and they're going to focus on one, potentially the other 3, but definitely one, violated the FDCPA. So therefore, they send it back to the district court, the trial court, to carry on with the case. So here's the standard, because you need to know what the standard is, what the rules are, as you evaluate whether a case should have been dismissed or should not have been dismissed. They say, we accept as true all well-pleaded factual allegations, draw all reasonable inferences in favor of the plaintiff, the consumer. And they say, look, normally when we're trying to figure out is a disputed statement false, deceptive, or misleading, it's a fact-laden analysis, and therefore court may not dismiss the complaint unless it's plainly on its face not misleading or not deceptive. And they say, look, the district court, that's the federal trial court, must tread carefully because district judges are not good proxies for the unsophisticated consumer. And so what they're saying is, look, federal judge, the test isn't whether you would have been misled. The test is whether an unsophisticated consumer, and by the way, in other circuits, there's a slightly different standard, what we call the least sophisticated consumer. But it's the same point. They're saying, look, it's not, will this trick a federal judge? Okay, that's not the test. The test is, will it trick an unsophisticated consumer? And so you got to be careful because the temptation is for a judge to say, well, I can read that letter. It wouldn't trick me. Well, that's not the standard. So I say, well, let's look at the specifics here. And they say CMS sends out letters. Debt collectors be happy to recover any amount of money because by the time they get involved, many of these debts will not be recoverable. And so these are form letters, but they're individual payment options. And you'll see they do this, and there's nothing wrong with it, but trust me, this is not an accident. They don't say, we'll reduce it by 30%. They say 29%. And so it's all these very odd numbers. That's why if you see something on TV or the internet where it'll say, using this in my business, I made an extra, they don't say $15,000. It's $14,927.33. Because when you get very specific like that, it tends to lend an air of credibility to it. So this is 29%, 24%, 19%. And the key part is in parentheses, a savings of 548, 454, 359. So these are 3 options. And then the letter says settling a debt for less than the balance owed may have tax consequences. And discover, because the debt collector wasn't saying they own the debt. They're saying we're just collecting on behalf of Discover. Discover may file a 1099-C form. And so the court says the language at the crux of this lawsuit is a part of the sentence which contains the following 6 words. Discover may file a 1099-C form. So they call that the 1099-C clause. They say, but look, that doesn't occur in a vacuum. It's on the heels of the one that says settling a debt for less than the balance owed may have tax consequences. So that's a tax consequence clause. And they say, did that 1099-C clause violate the FDCPA? So the consumer alleges 2 sections of the FDCPA, section 1692E and 1692F. So 1692E is, did the debt collector, it says creditor there, but they mean debt collector, did they use false, deceptive, or misleading misrepresentation or means in collection of the debt? In other words, did you do anything that tricked me, lied to me, hid the truth from me, kept something from me, deceived me? That's section 1692E. Now 1692F is debt collector may not use unfair, unconscionable means. So is this something that you did that was unfair? Maybe it wasn't a lie, but it was unfair to me. So I'll give you an example. If they lie about how much you owe, well, that's a lie. But if they tell the right amount about how much you owe, but they call your mother-in-law, they call your neighbor, they call your preacher, your priest, your rabbi, they call your college roommate, well, they didn't lie, but that's unfair. So that's 1692F. So a lot of times these sections merge together. In other words, what is deceptive is unfair, and what can be unfair can be deceptive. But the court will look at them somewhat separately here. And they say, look, language of a collection letter can be literally true and still be misleading in a way that violates the act. And the test in the Seventh Circuit is the unsophisticated debtor. Again, in other places, it's called the least sophisticated consumer, which if you sort of ranked them, you'd say least sophisticated consumer is a little bit lower standard. Unsophisticated debtor maybe is a little bit higher standard. So her knowledge is not as great as that of a federal judge, but is more than that of the least sophisticated consumer. The act protects the unsophisticated debtor, but not the irrational one. So I want you to see this case because I think it's a very important case, and you may have violations if you're getting these types of collection letters, but also shows us a good way to analyze the law. Where do we start and how do we carefully read these cases? Because on the surface, there's a case that they just ruled on, I mean, pretty recently, that would seem to just completely gut the consumer's case here. But it turns out it doesn't gut the consumer's case because it's slightly different. So I say, as is often the case, a good place to begin our legal analysis is that which is settled. Recently, in the Dunbar case, we evaluate a very similar tax consequence clause. This said the settlement may have tax consequences. We said that this warning is literally true and is not misleading, and so therefore did not violate the FDCPA, even though the consumers at issue in that particular case were insolvent and would not have had to pay taxes on discharge debt. Let me explain that. There's what's called an insolvency exception. So let's say that the amount forgiven is over $600 in principal, and we'll get to that in a minute. Then, yes, that gets put on you, but if you are insolvent under the definition of the IRS, then you don't have to pay taxes on that. So in this Dunbar case, it was over $600, but it turned out the consumers were insolvent, so they would not have to pay taxes on this. But the court still said that the letter that said, hey, you may get hit with 1099 is true, and it may have tax consequences. And here's why. They said may does not mean will, and therefore the statement's true on its face. An insolvent debtor can become solvent at any moment, and the debt collector has no reason or way to know whether an individual debtor is solvent or insolvent. So you could be solvent when they send the letter, and then you know, maybe all your assets are in a house and it burns down, you don't have insurance, and now you're insolvent. So how does the debt collector know that? Well, they don't know that. So by saying may rather than will, the debt collector described an accurate scenario. The information is only in the hands of the debtor herself and not the debt collector. But information about filing a 1099-C form, on the other hand, is information within the knowledge of the creditor. So that makes it different than the Dunbar. That's why they kind of broke it up. Remember, if we back up here, they say this is the 1099-C clause, and then this is the tax consequences clause. In that Dunbar case, it was the tax consequence clause. But here, it's the 1099-C clause. The creditor knows whether it will have to file a 1099-C. So you're required to file a 1099-C form if it's at least $600 in principal. Well, the creditor knows whether it's offering to forgive more or less than $600 in principal. But the debtor's not going to know that. Think about it. How does the debtor know how much is principal, how much is interest, how much is late fees? And this is the point the court's making down here. Even now, as this case has wound its way to this court, we, the 3 federal judges here, still do not have a clear statement about the amount of principals willing to forgive. And that's why the other letters, they're not sure about whether those would violate the law, because those amounts are over $600. But the letter that's at issue here, if we back up, remember, that's under $600, under $600, under $600. So it doesn't matter about principal interest. It's clearly not over $600. So let's go back here. So to summarize the law, it's permissible for a creditor to make a, quote, may statement if there's any possibility an event might happen. And so it's permissible to say settling a debt for less than balance owed may have tax consequences. However, it's impermissible for a creditor to make a may statement about something that's illegal or impossible. So I've used this example before. This is probably 15 years ago. We sued, I want to say it's Portfolio Recovery, because they were sending out collection letters that said, and this is debt that we had our date of delinquency about 10 years before the date of the letter. The date of delinquency is what triggers the 7 years, or depending on how we want to think about it, maybe 7.5 years that negative information can be reported. Well, this was 10 years, clearly beyond that time, and they said, we may credit report on you. So we sued them. We're like, there isn't any may about it. It's impossible for you to credit report. There's no circumstance in the world that would allow you to credit report on it. So you lied in this letter. And that's what the court's going to say here. It is impermissible for a creditor to make a may statement about something that's illegal or impossible. So a creditor may not state a court could allow attorney's fees where that's not allowable, nor may a creditor state late charges might apply when legally they could not. Although it is not technically illegal or impossible to file a 1099-C form if the amount's under $600, a collection letter can be literally true and still misleading. And the defendants, and they have to, okay? I mean, let me just say this. No creditor sends out a 1099-C for less than $600. Discover would never file a 1099-C form unless it's required to do so by law. So that means forgiving $600 or more of principal. So if we look at that November 11 letter with those 3 settlement options, Discover would never file a 1099-C form regardless of which settlement offer the consumer accepted, because in no circumstance would they be forgiving at least $600 in principal. And just as a reminder, here are those 3 numbers, all below $600. And so therefore, the consumer could plausibly allege that it is in fact misleading to state that Discover may file a Form 1099-C when it never would. And so unlike Dunbar, the debt collector has within its own knowledge all the information it needs in order to know whether such a form will or will not be required. So that's distinguishing from the Dunbar case where, as far as whether I, the consumer, am insolvent, well, only I know that. The debt collector doesn't know that. Well, here, it's the opposite. I don't know how much is interest, how much is principal, but the debt collector does. And whenever they say creditor here, just usually substitute in debt collector. They're just a little loose with that language. So here, the debt collector is sending out individual form letters that have both the knowledge or the ability to acquire the knowledge and the capability to include the 1099-C clause in which it would be forgiving at least 600 in principal, and to exclude the clause for less than 600. Now, I don't know what the debt collector argued, but I can tell you from doing this for a long time, debt collectors will say, well, we have a form letter. It's in the form. We can't change the form. Yes, you can. Okay. It's a field. It's a, you could put in there a checkbox, if more than 600, then include the clause. If less than 600, do not include the clause. They can certainly do that. And so generally the courts are not going to give them a break when the debt collector says, well, we're too lazy to make two form letters or to make the letter variable. Obviously, we know it can be variable because they're putting in like 29% and doing the math. Well, if you're doing the math, you can figure out there's no forgiveness over 600 principals, so leave out that clause. All right, so the district court relied on the reasoning of Dunbar without recognizing the material distinction between the tax consequences clause, 1099C clause. Again, this is a really important concept. We can look at a case, and maybe it's good for us, a previous case, but we still have to analyze it closely and say, well, can I rely on that? So in the law, we call that being on all fours. It's directly on point. It's like you lay, my piece of paper on top of the piece of paper of the court, and they just fit together perfectly. But the negative cases, we can't just assume, well, it's kind of similar, so I don't have any hope here. No, look at it carefully, because maybe it's not quite as similar as it might appear at first glance. So that's why we have to really study these cases. And then the court says, moreover, the language is misleading in a material way. So this is at 1692E. The reference to a report to the IRS may instill angst in the unsophisticated consumer. So they say the district court did not consider the psychological coercion that a threat to involve the IRS might have on the consumer. And they cite to a Third Circuit case from 2018, the Schultz versus Midland Credit Management, that presenting a false or misleading view of the law designed to intimidate the plaintiffs into paying the outstanding debts. And they say, look, our decision is consistent with what the Third Circuit did in the Schultz case. So in that case, the Schultz case, the letter said, we will report forgiveness of debt as required by IRS regulation. Reporting is not required every time a debt's canceled or settled. Might not be required in your case. And they said even that conditional statement, it's not enough. It presents a false or misleading view of the law, one designed to scare, intimidate the debtors into paying the outstanding debts, even though they knew any discharge of the debt would not result in a report to the IRS. So it must have been under 600 in principal. And then going back up here, mention of the IRS situation where there's no set of circumstances which the IRS would be involved could mislead a person of modest education, limited commercial savvy. Okay, it says even where the Dunning letter 718, and again we're talking about 600 or more, and it says the debt collector does point to one district court opinion when they found it was not misleading. But in that case, there were two pieces of information. First, the amount of the debt, which was under 600, and the second, that any settlement write-off of 600 or more may be reported. And so that judge in Indiana said, I don't think that's deceptive or misleading. And the court says, well, that kind of puts the knowledge back in the hands of the debtor, the consumer. And so the consumer can figure it out. And then they say, but look, we don't decide if we would rule the same way on this. And so ultimately they vacate the judgment, district court, remand the case for further proceedings. So when we're looking at things from a debt collector, when a debt collector says something, here's sort of the bigger picture beyond the 1099-C. When a debt collector says something, can you show that that would never be true? Okay, so I'll give you an example. If a debt collector said, we may sue you because this is within the statute of limitation, and it is clearly beyond the statute of limitation, well, then that would not be true. Okay, they lied about it, and they're threatening us with something. What if they put out something that they knew was not true, but they use language like, well, it may. I mean, let me be ridiculous here. If you do not pay this debt, we may come to your house, grab you and your children, strap all of you into electric chairs, and flip the switch and kill every one of you. We may do that, or we may not. Well, they could say, well, we didn't say we would do it. We said we might do it. Yeah, that's still wrong. Okay. If there's no chance of you being able to do that, you can't say it. And so we're always looking at this credit reporting, suing, we're going to get attorney's fees, or, maybe they're writing you a letter in a state where they're not allowed to seize your property with a judgment. And if they say, and we may seize your property, and in your state they can't do that, or maybe because of your status, you're disabled, or whatever the situation is, if that's an impossible statement for you, then that very likely violates the FDCPA. So if they say, regardless of the source of the money, we can go garnish your bank account. Well, that's not true. If I have veteran benefits in there, if I have disability benefits in there, they can't go garnish my bank account. So that statement is not true. So that's what we're looking for. And again, last time I'll say it, it really teaches us you've got to dig into these cases. You can't just sort of say, well, somebody told me that they heard one time that, Smith versus Equifax case says, or means this. No, go read it yourself. Okay. Look at it yourself. Study it, because it may not be as good as you think, or it may not be as bad as you think, but you have to really study it to pick up on it. So appreciate you guys watching this video. At this moment, I don't have another one in this series planned. There certainly are other cases out there involving 1099-Cs, but if there's something in particular that you're interested in, just either let me know privately or put a comment up, and I'm happy to look at that. And I want this channel to be beneficial to you and to meet your needs and answer your questions. So definitely let me know what's on your mind, and I'll do my best to put out a video, and then you can take that, whether you agree with it or not. Hopefully it gives you a little bit of information as you ultimately do your own research, your own due diligence, and make your own decisions. Okay, have a good one, guys. I'll talk to you later. Bye-bye.